Hey guys, let's get back into the Smithline situation and see what's happened since the last time we talked about it. So let's set the table again. Ashley Smithline has her own case as a plaintiff against Marilyn Manson in federal court. And then she was going to be deposed as a witness in the Bianco versus Manson case. And the same attorney represents her in her case against Manson and her as a witness in the Bianco case, as also represents Bianco as plaintiff in the case against Manson. And the defense attorneys are the same all the way around. So the attorneys are all the same group of people, but that's the situation. She's her own plaintiff. She's also a witness in this other case. And if you remember, it was referenced by Manson's attorneys that she was going to be deposed as part of their support for holding off on the anti-SLAPP hearings until they could get some discovery done in the case they have against Evan Rachel Wood and Ilma Gore. So that's kind of the situation. Now, if you recall, in Ashley Smithline's principal case, her attorney moved to withdraw himself as her attorney. He wanted to get out of the case, that he was terminating his representation. So let's go over where that stands in her case, because it's really kind of all that's happened there. The action's been elsewhere. He files this motion. That happens sometimes. Things don't work out for whatever reason, and the attorney's going to leave the case. But once you've appeared in the case, as mentioned before, you're going to have leave of court to get out of the case. So that's what he's asking for. He's asking for the court to allow him to leave the case, and saying that he has agreement with his client and he's terminated representation and just let me out of this thing. And that is set, I think, for the end of the month for its hearing. Manson's attorneys finally filed a response to that, and they don't oppose it, but they did ask that they be provided with the current contact information for Ms. Smithline prior to Ellwanger being able to leave the case, so that they know how to serve her with papers and things in the case. And that's also an appropriate request. In the Markle versus Markle case, Samantha Markle and her attorneys were wanting to part company early in that case, and the court denied the motion originally because she didn't want to provide her contact information. So the court said, well, we're not going to let you out of the case yet, because somebody's got to be there to pick up service and do things like that for your case. So it's reasonable for Manson's attorneys to want that. So I think they're going to have to deal with that on the plaintiff side, at least prior to or at the hearing. Because if they say, well, he wants to get out of the case and we're not going to tell anybody where to serve any documents or do anything, I don't know that the court's going to let him out of the case in that situation. But he may provide that information there. She may provide that information there. Who knows? She may come up with a new lawyer by the time this thing is heard. That can happen too. But that's where that sets. So they've got an upcoming hearing on that. Not a lot of drama there, just his motion to withdraw and their reasonable response that, well, we need information on if she's going to represent herself on how to contact her for the papers in the suit. That's that box, right? Now let's go over to the Bianco side, because that's where the action happened. And if you remember, she was subject to a subpoena in that case as a witness in the Bianco case, represented again by the same attorney, she and Bianco. So her attorney, when he filed a motion to withdraw, also filed a motion to quash or modify the subpoena for her upcoming deposition, saying, hey, I'm leaving the case. I'm terminating representation. That's pending over here. Let's stop this deposition, hold off on it. And he's asked for 90 days for her to either figure out how to handle her case or get another lawyer. And he doesn't think it's fair if she has to be represented in the deposition by a lawyer who's in the middle of withdrawing from a case. I don't know that the time frame he's asking for delay is particularly fair, or that he's right that she shouldn't be represented by an attorney who is withdrawing. But those are his arguments. It does seem to make some sense, some amount of delay, and just let him get his withdrawal motion done and maybe rekey this deposition shortly thereafter. But anyway, he's asking for 90 days, and those are the reasons why he's doing it. But where the fireworks really started in that case, where Manson's attorneys didn't take kindly to that situation and filed a response to that, resisting his motion to quash or modify the subpoena. And in it is where they put a lot of their bombshell material, saying that Smithline had contacted them, called her attorney a lying liar, that she would trust a fruit bat over her own attorney, that she didn't miss the deposition because of the psychiatric treatment she was doing a shoot at a hotel, putting up some more of the now famous and never-ending hearsay DMs about how she had allegedly fired her lawyer earlier in the year. I'd even heard that rumor, I think even before he filed his motion, but there's so many potential Ashley Smithline DMs out there. Who knows what's real and what isn't real? Regardless, they put this stuff in there and saying, "Look, does he even represent her anymore? What's really going on here? This is all kind of a subterfuge to dodge this deposition." So that's what happened there. A lot of fireworks there, a lot of nasty correspondence entered, and a lot of people were asking questions like, "Well, wait a minute, how if she fired him earlier, how come he's still on the case?" And that's a good question because your client can fire you, right? They can fire you, and if they do fire you, you need to explain to them what the consequences of that will be, and then you need to get in front of the court as soon as possible after that happens and get it out of the case. So that was the side of the story presented by Manson's attorneys, allegedly presented by Smithline. And some were taking that as gospel. Look at this kind of terrible plaintiff's attorney. He stayed in the case when he shouldn't have. Of course, all that's potentially true, but what we didn't hear and didn't know, still don't know, is what his side of the story is. I don't know that we're going to know that, or this particular our business. I mean, normally people want to withdraw out of a case. The idea behind the court situation is to ensure that the case can proceed in an orderly fashion, that there is enough information available to establish that there is this conflict. Then you let the attorneys out of the case. You don't do some wide ranging investigation into confidential information between the attorney and their client or attorney client privileged information. You're not supposed to do that. You're not supposed to need to do that. I mean, how's that anybody's business? If you want to fire your lawyer or your lawyer wants to fire you, then just make sure everything is going to work out okay and then let them go, right? But this kind of blew this open with all these communications allegedly from Smithline to other people on the internet and also directly potentially to Manson's attorneys themselves. Now, there's no doubt all of this represents an extremely strange set of circumstances. Again, not the motion to withdraw, but all this correspondence that Manson's attorneys were able to bring up, not in the context of the actual withdrawal motion, which is really kind of none of their business as long as they get what they ask for in that case, which is how to contact whoever is going to be the plaintiff in this case or representing the plaintiff. They were able to do it because of this subpoena in the Bianco case. So they bring in all this information to show some context to the situation. The allegations that she had tried to fire the attorney earlier, the allegations that she wasn't where she said she was or missing the deposition for the reason she said, and all the kind of explosive things that allegedly that she sent them and other people. So how much of all of that is true or even really from her is nothing I know, but I can say that that was a good week for Manson's attorneys because they gained a lot of momentum in this. I mean, it just caused kind of a firestorm inside, I suppose, that the Smithline case, and certainly on the public side, it made it look like it was in disarray. Somebody had asked me, well, what would you do if you were Bianco right now? How would you be feeling? And my view of that is, well, if you're otherwise satisfied, you just sit tight because in cases, storms can come and storms can go, and you don't make big decisions in the heat of the moment on how you handle your cases, right? So you got to wait and see what goes on. And this has died down to some degree, although it's quite interesting when it occurred. There has been another development, which is that the plaintiff's attorney filed a reply in this case and said that a lot of this information is just dubious, spurious. It comes from a place of no known provenance. The double hearsay DM exception, which I agree with him on, like, how can you really trust that kind of stuff? He doesn't go into great detail in the reply about some of the particulars of the alleged emails between Smithline and Manson's attorneys, and I kind of don't blame him for that. But he does make the case to the court that, look, I've got a lengthy written record between my client and myself that shows that I'm acting according to my client's directions, and I can and want to show the court that in an in-camera inspection to show that the narrative put forward by the defense attorneys is not correct in this case. That what I'm doing is according to my understanding and instructions with my client. Everything is the way that I've said it, and they know there's a motion of withdrawal going on. Why can't we just let that motion of withdrawal happen, and then she can be deposed at a later date when she's either representing herself or represented by somebody else? So for those who think that, well, the goods were there to show that he engaged in misconduct when she tried to fire him and he wouldn't be fired, you need to pay attention to what he's saying here because he's putting a lot on the line, which is he's saying, I will show the court in camera, which means in the judge's chambers or outside of view of the public in secret. I will show the real story on this. So if the judge were to take him up on it, he's going to have that because he's put in a pleading that he's got this stuff. So I think, as I wondered, he's probably got his own side to this story, and the reality of what's going on is probably a lot more complicated than even the complicated text exchanges appear to reveal. So take that for what it's worth. But again, I'm not assuming anybody's done something wrong just based on what you happen to see on the internet put out as communications by people, because there's so much in this case that is not proven to actually be from who it's supposed to be from. It just could be that you don't want to go too far out, as I said in an earlier video, on these leaked DMs or double hearsay DMs, because do you really know what the provenance is? So the judge is going to, the judge knows how to judge evidence, and the judge can look at this information and all that and make a decision on it. Now, when I'm saying that the plaintiff's attorney has told the court, look, I've got the goods on this, I can show you in camera, everything is exactly how it's supposed to be, I'm not, by saying pay attention to that story and give credit to it, that don't judge the guy because you don't know what all the facts are. I'm not suggesting Manson's attorneys have done anything wrong either. They have the information they have. They put it in front of the court. What I am saying is they don't have all the information. And so he may have things that show what they said lack the right context, or actually factually incorrect, even if it was, if you all you had to look at was that, you'd have this picture. If you have everything the plaintiff's attorney has, you'd see this picture. Also, some of it is DMs from people on the internet, and we've all seen those. I mean, if you've paid any attention to this case, have you not seen DMs from Ashley Smithline? Had those sent to you of varying sorts of she's hacked, she's not hacked, and all this stuff. I mean, it's constantly happening, right? For months and months and months and months and months. And to my knowledge, she has not made public statements on the status of her case or what's going on or anything else. So everything has to be viewed with I feel like a little bit of suspicion there. Just don't be certain. If you see something that, well, oh wow, look at that, that's pretty exciting, I'm going to assume it's true, because you really don't know. So there's a lot of that going on. In fact, I was contacted by both sets of attorneys in the case about information that they were not wanting out in the public, and hoping to corral that if it was there, and try to cooperate with them on that. But I sympathize absolutely that there's a large desire for information, and also a desire to keep people's private information appropriately private. And that leads to the situation of where there's things out there you just don't know if they're true or not, right? So we'll just have to see on this. And I will say that it's exciting, it's kind of titillating, but it's what's happening right now with this dispute over counsel and all this other stuff. It's not the merits of the case, and I really rather see cases decided on the merits. I was looking forward to the deposition, and also still am, in the Manson versus Wood Gore case, to get some facts out there, to develop the factual narrative of the case for both parties, both sides, in all these cases more, because that's really what it should be about, right? But when things like this happen, they take up all the oxygen in the room, and that is what it is. And there's another oxygen taking element here, which is the plaintiff's attorney in a Bianco case, filing for Bianco, not for Smithline, filing for Bianco, has filed a motion for sanctions against the defense. So he's asking the court to punish them for something. But he asked for leave to file this under seal. In other words, the public will not see what he's talking about, not even the arguments for it. And that motion to file under seal was unopposed by Manson's attorneys. Not that they're not opposing whatever his argument is, but they are not opposing that it's filed under seal. So I suppose they know what the argument is and whatever, and they're not going to contest that it's something that shouldn't be in the public. And the court has granted that motion. So now the application to file under seal has been granted. So I think he's even filed the documents, but they're all under seal. You're not going to know what they are. And the court is going to rule on that, I believe, sometime mid-October. Will you know what the court decides? Maybe to some degree, and maybe not. We don't even know what they're arguing about. We can all have a guess if you choose to have it, but that's all you'd be doing because you don't know what the information is. All we have is what was used to justify the filing under seal, which was this language. It said, plaintiff's motion for sanctions involves the discussion of highly sensitive information, which, if publicly filed, would cause plaintiff immediate and irreparable harm. This application is supported by the accompanying declaration of the attorney in support of the application for leave to file under seal. He met and conferred with the defendants, and that's that. And the court ended up granting that motion, so it's all under seal at this point. So that's what's happening in those two cases right now. Not much in the Smithline case proper, other than waiting for the court to decide on the motion to withdraw. And then now you've got this quashing of the subpoena issue, which is set, I think, also for the end of this month, and then a motion for sanctions, which will be heard sometime in mid-October. So that's what's going on right now. So that leaves those cases in a little bit of a limbo there as the temperature starts to come down some to get some of this extraneous stuff decided and move back to the cases proper. And then we will wait and see, which will happen before the federal court acts on these things, what goes on in the state court in the Manson versus Wood-Gore case in the deciding of whether Manson gets discovery or not. And when Manson's motion for discovery is decided, the court will then set the dates for the anti-SLAPP motions to be heard. And how far out they go probably depends on whether the discovery is allowed and how much discovery is allowed. So that's what's going on in these cases right now. And we'll see what happens next. Thanks.